In an earlier part of these lecture recordings, I outlined all of the elements that are required for a contract to exist at common law. And one of the things that I identified there, and that I hope you understand by now, is that the elements, so the fact of an agreement, offer that has been accepted without variation, consideration, so the exchange of promises, the exchange of obligations, an intention to enter into legal relationship, and certainty as to the subject matter and to the terms of the arrangement. These things together create a contract, but none of those things actually require for a contract to be in writing. So we can make a contract, all of those elements can be present without any writing at all. So that kind of leads to the question, well, why do we have so many written contracts, and what does this mean? Now, clearly there are advantages to having contracts in writing. They provide certainty because they clearly outline the rights and expectations. They can offer a definitive record in the case of future disputes. I mentioned earlier that we have the parole evidence rule, so that when there are disputes about something that is in writing, then evidence of separate or inconsistent conversations that vary or are inconsistent with the written document will not be admissible in court. It's also important to know that they can be enforced even when a party to them isn't aware of all of the terms or hasn't read the document. And clearly this is something that businesses rely on quite regularly. The whole process of having terms and conditions that are on a website, or that you have to tick, hit a link to go and see, there's a kind of reliance on the assumption to a certain extent that customers probably won't read the fine print, but we know that they're going to be bound by it anyway, even if they've never actually seen it. Now, in a subsequent video, I'm going to talk about the ways that the Australian consumer law steps in to try and make this situation a little bit more fair by imposing rules in relation to the fairness of the terms and conditions in contracts that aren't negotiated. But for now, it's important to just remember that general common law position that there's nothing illegal about a bad deal, and that consideration, while it needs to be something of value, it doesn't need to be valuable. It needs to be real, but it doesn't need to have any particular value. And the whole public policy premise is that people are free to create whatever private laws between them that they wish. Even so, in order to enforce certain contracts covering certain subject matter need to be in writing before a court will address any disputes that relate to them. Doesn't mean there's no contract there. It just means that actually the practical benefit of having an enforceable agreement is taken away because the courts just literally cannot enforce contracts of these kinds. Now, this is a very incomplete and high-level list. The rules are different in each state. So we've already mentioned contracts that deal with creating or transferring interests of land. It's a very broad provision. This one does apply in pretty much across the whole of Australia and is likely in common law countries that you're likely to see it consistently as well, but the devil is always in the detail, and it's something you would always need to check. The broad definition of land, it's not just the outright sale of a property, but things like leases, mortgages, easements, any kind of arrangement or agreement that impacts land in any way, whether you're borrowing or lending money, whether you're changing ownership or giving a right to use it. In order for it to be enforceable, it needs to be in writing. Now, this is not the same across all the states. In the state of Victoria, if a person is granting a guarantee, then the guarantee will only be enforced against somebody who has executed that guarantee, signed a copy of the guarantee. Now, that's not the case in New South Wales, for example. So it is worth understanding that there are differences there. So what is a guarantee? It's a promise to answer for a debt, default, or miscarriage of another person. And so, for example, if you co-sign a loan for somebody else's business, guaranteeing that you'll pay the loan if your friend defaults, then in order for that guarantee to be enforced against you, you would need to actually sign. You would not necessarily sign I've just said co-sign a loan, but you'd need to sign a guarantee document. Without the document, guarantee would not be able to be enforced in court. In some places, contracts that by their terms cannot be performed within 1 year from the date that they're made need to be in writing. This is an old one that goes back to the 1677 Statute of Frauds, the 17th century law that we mentioned earlier. So a service arrangement with a 3-year period of time, for example, needs to be in writing because it can't be completed within 1 year. So a really good idea because over a period of time, things change. Again, that is not necessarily the same in each of the states. I can tell you that that applies in Tasmania, but I have no idea off the top of my head whether it applies in South Australia or New South Wales. So let's have a look at some of the federal requirements. Under the National Credit Code, contracts that involve consumer credit, so personal loans, credit cards, mortgages, all of those need to be in writing. Contracts need to include specific information that is required by the legislation, including the interest rate, repayment terms, and a number of provisions that are there to protect consumers. And when you think about it, it's very rare to be in a position where you can negotiate an arrangement with a bank. Another kind of contract that always needs to be in writing is a door-to-door sales or telemarketing contracts. So again, the amount of money, there is a threshold amount that may apply in relation to that. You need to receive a copy of the terms and conditions if somebody comes to sell you something on a door-to-door basis, and the contract needs to include information about mandatory provisions, including, for example, the cooling off period, the period of time that the purchaser has to terminate the contract and reverse everything. Again, another one that's not universally required but is of interest is certain contracts relating to the transfer of intellectual property, so copyright, patents, those kind of trademarks. They need to be in writing, and this is so that they can comply with the formalities for registration or to provide for clear records of transfer. So there are lots of different types of contracts. This is definitely an incomplete list. Anywhere where there is a registration process to ensure that somebody's ownership is taken into account, so transferring a motor vehicle, for example, we need to have something in writing, even if it's just 2 signatures on a transfer form. So, of course, there are issues that come with trying to put contracts in writing. They can be costly and complex to draft and to negotiate. Online contracts are often agreed to without any kind of proper understanding. And so that can be really important to ensure that if your business is putting contracts online, setting its terms and conditions online, ensuring that they comply with the mandatory requirements of the Australian consumer law is absolutely fundamental here. Also, we need to think about the language that's used. Legal language can be difficult to understand, and the important terms, when they're buried in fine print, that can be unfair. So we need to think about mitigating the risk in ways that ethical and appropriate given the audience that we have, particularly in the context of the unfair contracts regime. I've got a couple of things here that I wanted to talk about. The ease and speed at which online contracts can be signed can also actually be a disadvantage. Well, a disadvantage to those who click, I agree, without reading or understanding the terms that they're agreeing to, and then taking on unexpected obligations or relinquishing rights without thinking it through. And again, sure, it might feel great as a business proposing those terms, but part of the process of operating a business is often entering into other contracts as well. So keeping track of and monitoring those arrangements can be really important. I've mentioned there are several areas where legislation requires certain formalities for a contract to be enforceable. So we talked about the types of contracts that need to be in writing. Those formalities provide a level of protection and certainty, but of course there are plenty of contracts that can be entered into and be legally binding without those formalities if the legislation doesn't require it. So the next thing we have to think about is what is actually required for a written contract as a matter of law. Typically, we're talking about a written contract as being any agreement that is documented in a tangible form. That can include a paper document, electronic record, or other form of digital storage. The key requirement is that the terms of the contracts are either are both permanently recorded and accessible in some way for future reference. It's worth taking a look at or being aware of the Electronic Transactions Act. Now, there's the one on the slide, the reference is to the Electronics Transaction Act 1999, which is a Commonwealth piece of legislation, and it has uniform versions or friends in each of the states as well. Now, this act actually applies to the one on the slide, it applies to Commonwealth laws, but it gives us guidance as to what features are acceptable as written for the purpose of a Commonwealth law, which helps us understand what features might be understood to be in writing for the purposes of private arrangements between individuals. So that legislation provides that electronic communications and signatures have the same legal standing as paper-based counterparts, providing and sets out the conditions that are required for that to take effect. This helps us understand that computer code can in fact be writing for the purposes of a document and for documenting the existence of a contract. Take a look at sections 10 and 13 of the Electronic Transactions Act. Now, remember that this relates to Commonwealth laws, but it gives us more general guidance. It helps us understand that electronic records can satisfy the requirement for written agreements and that electronic signatures, including digital signatures, are the legal equivalent of a wet or a handwritten signature. The Electronic Transaction Act 1999 Commonwealth is a federal law, but the Australian states and territories each have adopted similar provisions through their own Electronic Transactions Act, and ultimately the position is pretty consistent across the country. Okay, that's what I wanted to say about written contracts. In future videos, I'm going to be talking about the unfair contract terms very briefly, smart contracts, and the Australian consumer law generally. Questions, concerns, frustrations? You know where to find me.